Thank you, Magna. Very good afternoon, friends. If you're in a different time zone, then good morning to you or good evening to you. But my panel members and I are in the afternoon zone still. Most of us are waiting for 5 o'clock or 5:30 to start our the next stage of our life or next part of the day. Uh, the topic is a very interesting topic that we have today. A topic that is very current, tax controversy in Asia Pacific, current issues, cross border disputes, and audit trends. Tax departments, whichever country you belong to, have a common trait. They like to collect lots of taxes. Collection is what they like to do. And I guess that's why we're trying to understand from each other and learn as well what are the areas of concern. So please allow me to introduce our panel members in an alphabetical order. We have Jacqueline McGrath from Australia. She's a partner and a tax lawyer with Hall and Wilcox. Then we have Annie Pewa, Annie Lin, partner and tax lawyer with Teheng Law Officers of China. And we have Miss Lee Jia-young, partner and tax lawyer with Wilchon from South Korea. And we have Mr. Ko Chun Kiat, partner and tax lawyer with Raja and Tan of Singapore. And they are our panel members, and they have the more heavier task this afternoon to discuss the topic. I'm supposedly to have the easier task of moderating and posing the questions. And my name is Saravana, and I'm in a law firm called RDS Partnership in Kuala Lumpur. So we are trying to have the next an hour plus to be engaging and try to interact as much as we can. There are some questions that I've circulated to my panel members. I hope they had a chance to look at it, and I'll post that to them and get their views. And of course, anyone is free to anytime to chip in, panel members to add on to what another panel member has said. And for the audience who are joining us this afternoon, thank you. There are many ways to spend your Wednesday afternoon, but Tech Talk is also something exciting. And you'll see a chat box, and you can post your questions there. That's the best way to post. To my Malaysian friends who are listening to this webinar, please don't send me on WhatsApp your questions. Please put in the chat box because I won't be able to check my WhatsApp when I'm moderating. So there we have these purposes of the for questions. Please try to confine your questions to topic of conversation this afternoon. So with that, can I ask the first question to Jacqueline? Jacqueline, in Australia, the last 12 months, could you be so kind to share what is the most significant tax controversy or tax trends that the ATO have been looking at?
Sure, thank you. Thank you, Saravana, for having me today. So, by way of an Australian update, we continue to see a very active regulator in the Australian Taxation Office, particularly in the large business and multinational space. So I thought I would spend a few minutes just sharing, the key areas of focus for the ATO in terms of their audits and reviews. So in terms of the key compliance focus for multinationals, as you'd expect, international related party dealings continue to be a very dominant focus for the ATO. Under that umbrella is transfer pricing and particularly inbound supply chain distribution arrangements, intangible arrangements. So we're talking about intangible migration arrangements. So the ATO is very focused on what they believe is mischaracterisation of Australian activities connected with intangibles, and then associated with that characterisation of royalty payments. So aside from related party transactions, for large business and internationals, the other really big focus area for the ATO are cross-border investment structures. So they're looking at debt and capital structures, and particularly they're looking at debt creation, loading, and what they call debt dumping. So just in terms of that inelegant phrasing of debt dumping, the ATO's risk area is focused on excessive or what they believe is excessive or inappropriate levels of debt in an Australian entity that has the effect of, as you know, increasing deductions and shifting profits offshore. So, and that sort of feeds into a related focus area of compliance activity in this space, which is restructuring in response to our thin capitalisation rules. So, with effect from July 2024, the Australian government, as you might be aware, amended our thin cap rules, which applied much more stringent tests for analysing the amount of debt available in Australia. So, you know, and interest deductions and the amounts that can be claimed here. So as a result of that, really, what the ATO is seeing as a risk area sort of developing in the last 12 months is that they're increasingly seeing sort of global restructures happening that impact the debt situation here. So the ATO has also made it very clear that they're looking in real time to engage with taxpayers who fit within this top 100 or top 1,000. So, you know, ordinarily they're on regular assurance reviews here, regular cycles of reviews, but the ATO is really looking increasingly at real-time engagement with taxpayers on their restructures when it's happening and wanting assurance as part of that. And then, of course, I think what is common across many, but certainly for the ATO, they're looking at how taxpayers access treaty benefits. So the ATO are very focused on what they view as treaty shopping, which is essentially about obtaining the benefit of a reduced withholding tax rate under a DTA, a double tax agreement for royalty or dividends. So the ATO has published a tax alert that describes the typical, or what they say is a typical sort of developing issue, which is where you interpose one or more related entities between an Australian resident and the ultimate recipient, you know, of the royalty or dividend, where that interposed entity, where the problem is where that interposed entity is a resident, where they're a resident of a treaty partner jurisdiction, whereas the ultimate recipient is generally located in either a jurisdiction that doesn't have a DTA with Australia, or where they do, but the DTA provide a much less favourable treaty benefit. So that's probably in a snapshot, Saravana, where the sort of published areas of focus, and certainly what we're seeing on the ground as well with the ATO, they're very clear that their edict is to continue to hold the, you know, this sector to regular reviews and obtain assurance about their tax affairs.
Right. Jacqueline, just something that intrigued me when you mentioned about ATO focusing on royalty payments on intangibles and so on. Is it got to do or shaped by the fact that Australia has what you call a worldwide tax system, as opposed to like Malaysia or Singapore with a territorial tax concept?
Yeah, that's absolutely right. Yeah.
Yeah. All right. Thanks. And maybe I now go and ask, before I go to Singapore and Korea, China, I wanted to ask Jayong, how is the Korean tax department? You know, we know Korea tax department, they disclose all the statistics of how many MEPs and how many APAs they undertake, as opposed to my part of the world is all guarded secrets here. But Korean tax authorities have been far more open about things like that. But other than that, how's the trend in Korea with the tax department?
Thank you, Sarah Rana, for the invitation. So yes, I think especially if you look at the past 12 months, it's inevitable. We cannot go talk about tax in Korea and the tax authorities without mentioning the political situation. Precisely 1 year ago, we had a change in the administration that came about abruptly with a year-end attempt to declare martial law. So the situation that we had, that the new administration had, was that there was a steep drop in foreign direct investment as a result of this political shift. And we were working with marginal economic growth and rather significant loss of revenue. And this all has directly affected tax audit trends as well as tax controversy trends. And of course, some minor changes would be increase in corporate tax increase in corporate tax rates, which reverted back to what we had in 2022 by increase of 1%. But more notably, we see that there is more readiness and more aggressiveness in the tax audits itself. And this has also been accompanied by some legislative changes. So while there has always been in recent years, even before the change to the new government, there has been more and more a focus on raid audits and also criminal referral. But we more and more see that administrative penalties are being imposed, and there are legislative changes that introduce administrative penalties now, even for instance, for information returns that have been omitted by liaison officers. But more importantly, one major legislative change that started to apply since tax audits that commenced in September last year. So we have had these for a bit more for a number of months now, is that now it's possible for to have enforcement penalties, which means that if we previously, if taxpayer were subject to one-time lump sum penalties for failure to provide documentation, etc., over the course of a tax audit, we now have, the Korean tax authorities now have a legal basis to impose enforcement fines, which are not a lump sum, but accrue daily. And there's no upper limit upon how much can be accrued. And so the amount, it continues to grow as long as the taxpayer fails to provide the requested document. Right. Having said that, I note that these cases, these dispositions have not yet all made their way into courts, but we as tax advisors do see that they're starting to use them. And as tax advisors, some of the leverage that we currently have is that there still is a lot of uncertainty regarding the actual tax administration practice surrounding these enforcement fines. And so a lot of our argumentation and defense also focuses on ensuring that the document or the requests that are backed by enforcement fines are actually lawful. And that is the backbone of oftentimes the defense against trying to minimize the scope of documents that need to be submitted, the scope of data that needs to be provided. And one additional important legislative development that I would like to mention in conjunction to this is that very recently the Korean Attorney at Law Act codified the attorney-client privilege. So I think for colleagues in other jurisdictions or where this was already the case, this might come as a surprise. But previously in Korea, we did not have attorney-client privilege in the sense that our clients could invoke the privilege in order to refuse a submission during tax audits or other kinds of investigations. But now the codification serves as a legal basis that we find gives us as advisors a lot of strength, but also especially for us tax professionals in the context of tax audits, we expect that this is going to be very helpful going forward. The act, the legislation itself, it's going to come into effect next year, but once it is implemented, the privilege will apply to documents retroactively. So what we are making sure to advise our clients of is to have that documentation in place to make sure that it is clear that certain documentation data is subject and within the scope of attorney-client privilege.
Right. Oh, that's okay. That's interesting. Thanks, Jayong, for sharing that. If I may ask, any from China, China used to have death penalty in the past until 2011 for tax evasion. Of course, economic offenses have relaxed more. But what's the trend in China now? Any in the last 12 months in the tax department?
Yeah, in the last 12 months, I think just in the year of 2025 marks a pivotal years for the
Mm.
digital transformation of China's tax collection and administration. Yeah, firstly, China has built an interdepartmental information sharing mechanism between tax and such like company registration, the market supervision authorities. So supported by AI large models and big data technologies, it enables accurate early warning of corporate tax relating risks. We have already handled multiple cases triggered by this supervision upgrade. And secondly, China has intensified regular supervision over CRS information reporting and strengthened the guidance for high net worth individuals to declare their overseas income and fulfill tax obligations in accordance with the law. And thirdly, new regulations has been issued requiring internet platforms to submit tax-related information of platform operators, such as
Uh,
Pinduoduo, a leading Chinese e-commerce platform, became the first enterprise penalized for failing to fulfill such information reporting obligations. Yeah, in Shenzhen, which is compared to Shenzhen and the Great Bay Area, the most significant trend is the normalization of whole train and penetrating supervision. And over the past 12 months, leveraging the Golden Test Phase 4 system. Yeah. So have
okay.
such AI management. Yeah.
All
We
right.
have seen
Thanks. Thanks.
substantial. Yeah.
Right. And can I ask you a question? China is a vast country. Is for me, it's like a subcontinent on its own. Is the tax authority in Shenzhen, the way they look at tax audits, different from the one in Beijing or Shanghai? Are they more localized in the way they approach the issues, or they have a national issue to go through?
Yeah. And from the legal system, they're the same, all under the state administration. So,
Okay.
and as laws or the legislative regulations is the same. But the
Okay.
difference is their practical operation, how they enforce. And we can say which kind of tax, such value-added tax or the income tax, the different tax uh, for the local, which kind of tax is easily for them to collect. So
Mm.
they will use different measures to just collect the tax. So it is the different is the intensified intensity. Yeah,
Right.
just
Thank you, Annie.
different.
Thank you. Thank you for sharing that. Now I go to a more friendly jurisdiction when it comes to tax. Chunket, Singapore. There are not that many tax disputes in Singapore because it's a financial hub, and I guess Singapore's always, fashioned itself and promoted itself to be a business-friendly environment. But having said that, could you be so kind to share how is the Revenue IRS looking at issues in Singapore in the last 12 months?
Thank you, Saravana. As you rightly pointed out, yeah, historically, Singapore has generally been regarded as relatively predictable, rules-based jurisdiction, where actually most of the disputes are often resolved through engagement with IRAS, the Singapore Tax Authority, before escalating into formal litigation. So I think broadly speaking, that remains true, even though there's a gradual increase in the tax dispute here. It's still relatively lower than other jurisdictions in Asia. And the first trend that I would spot or observe here is that there's an increasing focus on substance over form. So essentially, we can see that in um, tax residency issues, where the taxpayer wants to rely on a treaty benefit and has to be tax resident in Singapore. IRAS is looking past the just the documentation and looking at the economic substance of the taxpayers, essentially where they hold board meetings and whether there are any good commercial reasons to set up a company in Singapore. They also
Right.
look at whether there are key employees, such as the chief officer or chief COO or CEO, being based in Singapore.
Right.
And they would actually raise such questions and not provide a tax residence certificate if they're not satisfied with the responses that the taxpayer give.
Right.
There's also another recent development in the Income Tax Act where there's a new provision that taxes capital gains that the taxpayer receive in Singapore for disposal of foreign assets. And if the taxpayer does not have economic substance in Singapore, for example, a certain amount of expenditure, certain amount of employees based in Singapore, um, then IRAS would actually impose tax on any capital gains received in Singapore from such disposal.
Okay.
Yeah.
Okay, that's it. So they are looking at management, control, and substance. So I guess the same trend like in Australia, substance becoming the buzzword
Yes.
now for the tax authorities. Right. Thanks. Chinky, since are they using AI in Singapore? How is it when it comes using of AI and data by the Singapore tax authorities? Any news on that?
I actually see that. I think they usually use it for forensic evidence. So it's usually in audits that they would apply all these AI tools to discover any discrepancy in maybe GST custom cases where the
Hmm.
values are underreported and they can actually tell there's a appropriate range for values of certain goods that are imported into Singapore. So from these AI tools, I think they can flag out key anomalies and then raise audits on these taxpayers.
Right.
Yeah.
So just to share to everyone, in Malaysia, the tax department has a unit called the intelligence unit. What they do is they get intelligence. In the past, they used to read newspaper. They still do. They read the business papers. There's a paper in Malaysia and I guess in Singapore too called The Age, which is the main business paper, the Financial Times equivalent here. But their main source of information is TikTok videos, especially these influencers and direct sell marketing people where they showcase their new cars, I mean branded cars, and they have a bait, a mattress filled up with cash, and they're doing so successful. They found all this cash from this business, and there they are. The tax department goes after them and says, "I'd like to come and talk to you, not paying taxes, and I saw all this cash on your mattress." And we see this trend, and then these influencers all getting all worked up. They say, "Oh, this all a borrowed money. I'm just showing to show that the business is flourishing." Of course, a taxman being taxman asks the next question: Who borrowed you this money? I want to go talk to him too. That's why no, they don't realize the taxman's probe. They keep probing you, and I tell my clients that the depth of tax department's probe is how my wife probes me on a Friday night when I go out after many happy hours and said, "Where did you go? Who did you see? Why?" And the probing goes that depth. So I say the tax department's probing is not superficial; it's a proper investigation. So how about in Korea, Jayong? Is the tax department using technology in a big way as well?
So I would have to say, with regard to more recent technology, most notably large language models of AI, etc., I am not familiar that the NTS, that is the Korean Tax Authority and the National Tax Service, has openly announced usage thereof. I understand that there are maybe certain concerns regarding data privacy and also concerns regarding sandboxing. So from that, I think with regard to that cutting edge technology and application of that, there is still a bit of a conservative side to it. That said, on a more related matter, the NTS does use its own digitized internal network proactively. And one of the more recent developments is also with regard to Pillar 2 and the global minimum tax. They do actually have their separate own database set up to process globe information returns.
Right. Oh, thanks. And Annie, I wanted to ask about China, especially in relation to transfer pricing, if I may, or how multinationals are responding to transfer pricing arrangements. Or is the China tax department very concerned about transfer pricing? Because inevitably, any product that we're using today has some origins or most of its origins in China, whether be it parts or whether it's being assembled in China. So undeniable, that the goods that we use on a daily basis as a mark, a Chinese mark on it in a way, directly, indirectly. So is transfer pricing a concern that you have come across for investors or businesses in China?
Yeah. The transfer pricing, we're saying from two field. First is the cross-border. Just from this field, cross-border issue is just showing CIS. Yeah, benefit from the CIS and OECD's regular rules. So this is very fixed and certain. They have their enforcement route to do. So in the year of 2025, maybe the same as the past years. Then this is for the cross-border pricing issue, just for their connected companies price transfer. And just in the domestic, this is more strictly more intensively, because the economy in China is not so good. Yeah.
Right,
So
right.
from the price transfer, the key issue is how is the price is reasonable, and the standard is different. Maybe each person have different explanation and different views, right? So different tax authority, they have different view to the price reasonable, right?
Right,
And
right.
this
When it comes to
just
benchmarking.
yeah, the essential is just from the fiscal income of the local government. Yeah.
Right.
So just from the first question you asked me, Shenzhen, Beijing, or even the Yunnan, different is different from their fiscal revenue.
Right.
Yeah.
Right. Yeah, because you're a vast country, and so things are approached differently. On that point, can I ask you, do you see more coordination between the Chinese tax department and authorities such as OECD when it comes to, TP, transfer pricing framework, or exchange of information? Do you see that happening? Question 7 in my list to you.
Yeah. It's very mature. So we cannot see that any change from the customs for the last years. Yeah. But
Right.
China is a very mature mechanism. to communicate with other countries, even such as the Europe countries or the USA or Japan. Yeah.
Okay. Thanks, Annie. But Jacqueline, if I may ask you from Australian perspective, when it comes to reading TP cases, I sometimes I keep myself entertained, if I may use the word loosely, entertained with TP cases, Australian cases. I think Optus, Glencore are some of the recent high-profile cases that have come from Australia. Could you share how is the ATO's mood with TP, and how are they treating investors in TP, especially multinationals coming into Australia?
Sure. Well, certainly with transfer pricing, there's been quite mixed results for the Commissioner in litigation in TP. It does become very evidence-based. It would be remiss of me not to mention the PepsiCo decision and its sort of aftermath, because that's probably one of the most recent cases. It was an embedded royalties case, as I'm sure you're aware, but in August of last year, our High Court, by a 4-3 majority, had dismissed the Commissioner's appeal and held that no portion of the payments, so this was payments from Schweppes Australia to PepsiCo in Singapore, for the concentrate was a royalty for royalty withholding tax purposes. And the other part of that case was looking at our diverted profits tax. So PepsiCo, the finding of the court was PepsiCo didn't obtain a tax benefit for DPT purposes. And this was really, the first case, a test case really, to consider both the embedded royalties and the DPT, and the Commissioner was unsuccessful on both. So it's really quite a significant case, even though it's not transfer pricing necessarily, but it's a really significant case because it was the first of its kind to challenge the diverted profits tax regime. It is sometimes considered as part of transfer pricing considerations and what arm's length, and really what sits. DPT is essentially a 40% penalty tax that can be applied where the ATO forms a view that there's been artificial shifting of profits offshore into low tax jurisdictions, which is, as you know, a lot of what transfer pricing is really dedicated to. So, a very significant matter. I think the principle is that you look clearly at what is actually being paid for under the contract, looking at the IP rights and tangible property, if it can be cleanly separated. What comes from this case is that really payments might not be characterised as royalties. Of course, the ATO has a differing view. They look at apportionment. So their view is that if payments are for, at least one party's IP, an apportionment's necessary. So even with PepsiCo decided, I think we can expect that the ATO is going to continue to challenge embedded royalty structures, but just perhaps on a narrower factual ground.
Right. And I'm not so surprised, Jacqueline, you shared that. I acted for the ATO before in Malaysia. I went to court when when an Australian taxpayer who was a Malaysian citizen filed a case in the Malaysian courts against the Commission of Tax and the ATO and the Commonwealth because he had some issues in Australia, and ATO was all out to defend his position and so on. On that note, since you mentioned these three big names, especially PepsiCo and all that, could you share with the audience what lessons can multinationals learn from these recent, TP cases in Australia, and how could they manage their businesses better?
Yeah, so I've been thinking about that. I'd probably say two things. The first is very much engaging early and fulsomely with the ATO. Now, they have formal powers to request information. They've got powers for compulsory to compel for compulsory interviews with taxpayers and their executives, and so where issues happen is when that I see is when the audit is being finalised and the ATO prepare their audit report and issue it to the taxpayer for comment. You want to make sure that they have all of the relevant information and documents that shed light on it. Now, that might sound trite, but often we see audit finalisation papers issued by the ATO that say things like, you failed to provide any evidence or of X or Y. And there's many instances where you look back and realise that the ATO never asked for it, so you didn't provide it. Then the taxpayer at that point will supply, with their response to the audit report, their documents. So my sense is that that tends to mar the relationship with the ATO and the optics, perhaps. So I think it's actually important to really front end some of that thinking. And it's obviously important to answer the direct questions because of their compulsory powers that they have, and there's sanctions relating to non-compliance with those requests. But I think it's always worth having one or two people who are not necessarily involved in the response team to be thinking about the case a few steps forward and thinking, how do I make the ATO comfortable with our position? What can we provide to help this? So that's, I think, what I see as a little bit of a flaw in terms of review. The second thing that I would mention that is often overlooked is genuinely thinking about settlement or alternative dispute resolution with the ATO at all stages of review, the audit or objection, or in litigation. My sense is that sometimes there's a belief that settlement or broaching that subject should really only occur in litigation, and it appears weak. Sometimes I think there's a belief that it's weak to attempt resolution early for fear of it might signal you're not in a confident in your position. Obviously, every case needs to be looked at on its own facts, but and as the risks unfold. But I think that there can be so much angst for taxpayers and time and resources spent when the case, particularly for TP matters, they can be readily resolvable. If I can just add some colour to that, in the large business and cross-border space, the Commissioner, the ATO here, publishes very openly and candidly about what he sees in the market, where the issues are, how much tax they've netted through their compliance activities, but they also report on their settlements. And I think it's in this sector, and I think it's worth just highlighting what their last report was, which was in for FY25. They settled 18 separate disputes with public and multinationals, public groups and internationals. The total settlement variance was actually 36%. And what that essentially means is that the difference between what the ATO said was payable, in their audit report or their notice of assessment, and what they ultimately was the subject of a settlement, it was an average 36% less than what the ATO had done. And so had sought. And I should add that the report says that the 5-year average variance is actually close to 39% for settlements. So what that sort of tells me, or everyone, importantly, I think that the ATO are open to resolving because most of these cases in this sector are TP related. If it's an appropriate case early on, I really think the lesson to be learned is, consider alternative dispute resolution, because, the statistics are certainly stacking up to show that there can be a significant reduction. And of course, as you well know too, the time and resources in TP disputes, the impact for the businesses, for our clients and things like that is significant. So, certainly what I see in terms of potential areas for improvements in this space is, thinking about resolving or settling as early as possible.
Thanks, Jacqueline. To participants who are joining us, if you have any questions, you can post in the special box that we have, in the Q&A box. Please post your questions, and we'll do our best to respond if there are any. Jayong, how is the mood in Korea? Is litigation the order of the day, or discussions take place? Because sometimes you take the tax department to court to test them to see how serious they are. But as Jacqueline said, tax department sometimes run as a business too. They want to collect the revenue. So settlement sometimes allows them to collect the money quicker without spending too much resources on defending their position. Jayong, how's the mood in Korea?
So I would say that compared to other jurisdictions, though, it appears to be that in Korea, both the taxpayers and the tax authorities tend to be quite litigious. So we often see that, for instance, if a taxpayer takes a matter to court, it is as a general rule the case that the tax authorities will file appeals up to the Supreme Court. So that's basically to be expected, that a tax case that goes to court is going to end up, they're going to all three stages of appeal. And it may be a cultural difference, but definitely we tend to see a lot of litigation, which was, as a tax advisor and especially an attorney, quite a positive environment to be working in. But recently, we do see some taxpayers being more reluctant or being more wary, and seeing more inclination towards settlement as part of the tax audit. I understand that this has also, again, some influence from the political situation and the concern that the overall governmental atmosphere, if I may call it that, may have an impact on the judiciary as well. But of course, I personally inform my clients that that does not need to be a concern in weighing their options. But the numbers appear to, it's palpable that the numbers are going slightly down in this regard from the taxpayer side.
Thank you. Chunket, if I may just bring the audience to Singapore, we heard about, essentially when it's litigation means, or even settlement post-audit, it's all triggered by tax audit or tax investigation. And I guess Singapore is an exception to that kind of audit or investigation. I wanted to ask you from your experience being the hub for investments as well, especially for financial aspects, digital economy and so on. How would you advise, and how do you see multinationals reacting to this in terms of documentation, preparing for audits? Could you share some insights from your perspective in Singapore?
Sure. Yeah, that's a very practical question. I think in my experience, one of the biggest mistakes that taxpayers make is to assume that either the facts or, technical legal arguments alone will be enough. In reality, you need both. And I was actually involved in a dispute involving a Singapore entity within a multinational group that had undertaken certain financing activities like bridging loans in support of like the wider business of the group. And IRAS initially took the view that the income should be characterized as passive income rather than business or trading income. And that carries very different tax consequences. And during the dispute, it seemed like it was a narrow technical question about whether is it a passive income or trading income. But from a factual perspective, the taxpayer had to demonstrate that this was not merely a passive receipt of income, but an active commercial operation. So what happened was I think the number of loans were on the lower end, so maybe like 5 or 6. And Ira's first question was that it seems like it's not in the business of providing financing loans. And that what that meant was we had to show documentation that, for example, a broad level approval of the business model, commercial rationale for establishing the structure, ongoing credit assessments of the finance loans and risk monitoring, as well as internal governance material showing that this was actually a deliberate business activity that the taxpayer wanted to enter into. So we had to rely on contemporaneous documentation and provide legal arguments to explain why these activities should be characterized as a business income and instead of a passive income.
Right.
So
And
I think,
sorry,
yeah.
please. Continue.
So then I think the main mistakes or common mistakes that are made is that taxpayers tend to have or assume that contemporaneous documentation is not very important. But from this example, I think it's very important because without all these documentary evidence, IRAS may not have accepted our arguments just purely on the legal submissions. And I think there's also a fragmented approach to answering these audit responses because often the taxpayers tend not to have a coordinated input from tax, finance, the business side, legal operations. And I think once information is siloed into different departments, the responses can be incomplete, inconsistent. And when tax councils are engaged at a later point, it will be difficult for us to help reconcile these inconsistencies. So if I were to give a practical takeaway, it would be that usually successful audit defense requires strong facts, coherent documentation, and a clear legal framework to connect the two.
Thanks. Okay, there's a question from Mariam Sana. I think she's from Maldives, and she asked me this. She's asked this question: where proper TP documentation is not prepared, and the tax authority contests the transfer price of transaction, how would a tribunal or court entertain the admission of transfer pricing document, which is prepared after the assessment is released? So in other words, it's not done contemporaneously, but it is prepared after revenue raises an audit, probably made a decision and raised an assessment, then the matter goes to court. Would it affect the veracity or the strength of the taxpayer's case? Your views, Finket, how's it in Singapore?
Yes, in fact, I do have a live example where um the taxpayer did not prepare contemporaneous documentation, or rather more specifically, they have documentations that relate to previous years, for example, in 2018, 2019, but it was undated. So IRAS actually took issue with that and attempted to rely on a statutory provision in the Income Tax Act where there is a specific express requirement that documentations have to be contemporaneous in order to make, for example, a downward transfer pricing adjustment. And if we want to rely on that provision, we would have to provide dated documentation that had been carried out at that point at the relevant time. Fortunately for the case that I was helping with, we could rely on a technical argument where the years of assessment were before the legislative development or change that was introduced. And before 2019, the requirement of having contemporaneous documentation was not in the statute. So I would say that it is actually very critical to have contemporaneous documentation.
Okay. And Jayong, in Korea, is there a need to have a TP documentation contemporaneously prepared?
So from the tax authorities side, it does open up the possibility that the tax authorities are going to raise issue, albeit it may not be statutorily as clear as it appears to be in Singapore after their legislative amendment. Yet, of course, the tax authorities do insist, and one characteristic with regard to documentation in TP audit context is also that the Korean tax authorities are very eager also to obtain documentation from the overseas affiliates side.
Right.
So if the Korean taxpayer is not able to provide that, or is able or is only able to provide subsequent documentation, it is often the case that the tax authorities will try to then obtain the documentation from the foreign affiliates side.
Right. Thanks. And if I may now just ask another question from the audience. Again, Maria is very active. She's asked a few questions here. Could I probably ask Jacqueline? Jacqueline, she's asked us, how is the dispute resolution mechanism in your jurisdiction? Because in Maldives, and that's very similar to Malaysia, whereby after an audit is concluded, the next step is to file an objection to tax authority, which is then sent to the tax appeal tribunal and then to the higher courts. Mariam, same in Malaysia, same in Singapore. Singapore as well. You go to Board of Tax Review and then from there to the High Court. This is all the colonial legacy from the British tax system. But Jacqueline, you are a bit more different in Australia, isn't it? Now you have the AAT, if I'm not mistaken. Could you just guide us? How is it in Australia?
Sure. So with alternative dispute resolution, generally the process, if we talk about the dispute continuum, when it's with the regulator, it moves from a review or audit. If the taxpayer is unsuccessful, they lodge what's called an objection. That moves to a different area within the ATO, but it's still within the ATO. After the objection, if the taxpayer is still unsuccessful, they can move to external review, and the two options are either the Administrative Review Tribunal or the Federal Court, and they're independent. When I talk about ADR, when it's within the ATO, they do have certain products, if you like, with being able to facilitate essentially mediations. So they, particularly for the large, the multinationals and the large business, they have much more structured sort of mediations that they can bring in sort of external members of the bar to and experienced mediators to mediate it. And that's particularly if the tax in dispute is particularly large as well. But even informally, they do facilitate discussions between the tax authorities, the taxpayer, their representatives. They do have more structured as well. So they do have sometimes a more senior ATO officer unrelated to the audit or the objection sit and try and sort of mediate it. When you get to external review, when it's truly independent, both the court and the Administrative Review Tribunal have formal mediation and conciliation options as well. So you can, certainly the parties are less so in the federal court, but in the Administrative Review Tribunals, because it's a merits review, they do very much encourage the parties to attempt conciliation, mediation for that.
Right, thanks. My question to I'm moving to a different line of questions. I just want to ask you, is the geopolitical tensions, the global trade pressure and all that, and of course, the need to do supply chain restructuring with what's happening in the global trade environment, is that influencing tax audit or tax investigation in China? Is any influence in China, or is not much of bearing to domestic taxes?
Yes, such as
I hope it's not too controversial a question.
yeah, geopolitics. Yeah, it's influenced China. Yeah. I think now just between the China government will less to communicate with other countries' authority. Yeah, so just strictly to enforce the tax regulation in China, or even the non-residents, the income from China. Yeah. So will less communication with other country. This now is the, I think, influence most is from this.
Right. Thank you. And I'm going to, I've taken the key questions I have that are relevant to our discussion. I want to now go to panel members and get your final views on this topic. I wanted to ask, probably go to get a crystal ball to take us through this. Maybe I start with Chun Kiat. Chun Kiat, because I started last video in the first question, so the last question I want to go with you first. Looking ahead to the next 3 years, what do you think will define tax controversy in our region from your experience?
I would say that mainly the trend is still for Singapore, it's transfer pricing disputes. Seen a lot of disputes on transfer pricing, especially on intercompany agreements for licensing of intellectual property. This in fact I was involved in one in the dispute where the Singapore entity has various licensing arrangements. So one with a related party in China and a related party in UK. But the royalty rate for the arrangement between Singapore and China was, for example, 30%, whereas the royalty rate for Singapore and UK was at 10%. So IRAS actually came in, looked through the transfer pricing documentation and found that the range was too wide, because the range was around from 6% to 45%. So what I've seen is that not only is the documentation has to be contemporaneous, it has to be very robust and backed by economic and commercial realities.
Right. Thank you. And may I ask what we call Jacqueline, your thoughts on this as well?
Yes, I think similarly, transfer pricing is going to continue to be an area of focus for the ATO. One additional thing I would, if I have a crystal ball, I think that, and related to the transfer pricing, is customs valuations. So how they intersect with with transfer pricing. So the Australian Border Force, which is the customs regulator here, requires declared values on imports to reflect the actual transaction value. So what we're seeing a lot of is, obviously, the ATO is the main regulator where these transfer pricing issues are emanating from. They can be many years in audit and review or objection, trying to, get the point in the range where, both parties can live with that. But that inevitably arises, does require an adjustment to be made to the customs value for imports that have been made over that period as well. So I think if I was to have a crystal ball, it's all within transfer pricing, but I think we're going to see, because customs in Australia is also netting a lot of revenue from voluntary disclosures for retrospective adjustments as a result of TP as well.
Thank you. And how's the mood in China next 3 years, you think going to be?
We hold a view that the implementation and the coordination of the OECD second pillar global minimalized tax framework will be a decisive issue going forward.
Okay.
And divergences among countries in terms of implementation timelines specify the rules and the enforcement criteria will trigger a large number of cross-border tax disputes. And China is pressing ahead with the relevant legislation, such as the OECD Second Pillar Global Minimized Tax Framework, because China now have no such of the legislation. And matters concerning the confirmation of the tax jurisdiction, recognition of the permanent establishment, and digital services and transfers pricing, especially for the service trade, not the cargo trade. Yeah. And the service trade is the 最容易引起是 yeah, more liable to tax authority. Yes. So we can concerning and pay more attention to the service trade, this
Right.
field. Yeah. Because it's hard to proof. Proof is a reasonable price and substantial to support what kind of services provide and its price. Yeah.
Right. Thank you. And finally, Jayong, can I hear your thoughts on how you think Korea is going to move on this topic?
Sure. Considering the economic and also the political outlook for Korea, I do believe that the trend is going to consider with trend, meaning that there's going to continue to be aggressive or eager attempts at ambitious attempts at also tax audits, criminal referrals. And I would see this particular in areas such as P assessments, because oftentimes they are also tied with a substantial amount of assessments due to retroactive VAT assessments that are made possible, but also with TP. I think the TP audits, the trend that we currently have of the tax auditors applying various simulations and analysis, and also changing profit level indicators or using different profit split methods to reconstruct the taxpayers' TP policy. I do believe that that overall trend is going to continue and will necessitate vigorous preparation also from the taxpayers and advisors side.
Thank you. Thank you very much. And I think that is all I wanted to ask. Is there anything else anyone wishes to add before we call it a day for this afternoon? Not. Thank you very much. And we have done by 5 p.m. Is it 5 p.m., Jacqueline, for you now? Is it 5?
It is.
Perfect.
Yes.
And it's
Very
3
well.
o'clock. Another 2 hours before I hit the happy hour in this part of the world. And I'm sure you got hit it earlier than us. And thank you so much again, Jacqueline, Jayong, Annie, and Chun Kiat for joining us today. And for the audience, don't forget the annual Law Asia conference takes place in South Korea this year, 14th to the 16th of September. A good place to be there for party, good food, and of course, an intellectual conversation on this topic. And registration is open now, so early bird, you get good discount. And please come and join. And not to forget, if Korea, it takes too long for you to wait for September, August, you can go to Papua New Guinea. There's a Law Asia Environmental Conference taking place as well. And so please do join discounted rates for Law Asia members. So I've done my part promoting Law Asia and its conferences to you. And I hope to see all our panel members in South Korea too. And if any of you are thinking of becoming a speaker at the Law Asia conferences, please contact headquarters, HQ. The secretariat is based in Australia. Magda is there, Belinda is there. And I'm sure they'll be able to create more opportunities for you. Thank you so much again, panel members. Thank you, friends. Enjoy the rest of your day. Bye-bye.
Thank you all.
You.
Thank
Bye.
you all. Bye.